Hello, everyone. My name's Tim. You're watching Lost in Law. Today, we're talking about using your cell phone while driving. Why is this important? Well, I bring the common understanding of law to the common person. Most people are not lawyers, and yet the intersection of their lives and the law occurs daily. Using your cell phone while driving is just one such instance. Now, for most people and most incidents, it's pretty straightforward. You were on a call or you were texting someone, a cop sees you, pulls you over, and you are written a ticket. Distracted driving is a pressing matter, a matter of public concern. And so legislatures adopted language to forbid it. Now, the Highway Traffic Act or Highway Traffic Safety Act, depending on the province, are under provincial jurisdiction. So if you've watched this channel before, you'll know that I've specified that the Canadian Criminal Code is a federal statute. It applies to all provinces. A crime in one province is a crime in every other province. Regulatory offenses like highway traffic violations fall under provincial jurisdiction. So each province has their own version of the Highway Traffic Act. That means that depending on which province you're in, they have slightly different wording and therefore slightly different application. And it is incumbent on you as the driver to know the law and the jurisdiction in which you're driving. Ignorance of the law is not an excuse. So what you're looking at on screen here is a case out of the Court of Appeal of Newfoundland and Labrador. Their wording, which you can find right here, simply states a person shall not use a handheld cellular phone while driving a motor vehicle on a highway. So the very first question that comes to mind is, what does use mean? Now, we have definitions up here, but not for the word use. In this case citation here is, I'm not even going to try and pronounce that. But that's the case citation up here for you, if you want to have a look at it. But the facts are that an officer saw the suspect with a cell phone held between his head and shoulder. So, sort of like this. However, the phone was not making a call. He was not on a phone call, and he was not responding or in the process of reading any text. The phone was simply in its place. Now, the subject here claimed that they were manipulating the phone to move it from one pocket to another. It was not in dispute that the phone was not currently placing a call or in the process of texting. The Crown and the defense both agreed on those set of facts. But is simply holding the phone, is that enough to be considered use? So the trial judge in provincial traffic court said yes and convicted our unlucky person here. However, he appealed and was successful on that appeal. So in Canada, you can appeal traffic tickets up to the superior court of that jurisdiction. I'm not sure exactly what that's called in Newfoundland and Labrador, but in Alberta, that would be the Queen's Bench, the Alberta Queen's Bench, or King's Bench currently, because it's currently a king. So, but in 2006, where this case was cited, it would have been the Queen's Bench back then. So you can appeal your traffic ticket up to the next level of court, which would be the superior court of that jurisdiction. In Ontario, that's the Ontario Superior Court. Pretty simple. And then once you get a ruling from that level of court, you then appeal up to the Court of Appeals. So at Superior Court level, the conviction was set aside, so the Crown appealed. And we end up here at the Court of Appeal in Newfoundland. So, what is the meaning of use? And the court looks at a couple of things. They especially look at a patent case. So that's this citation right here. That's Monsanto Canada Inc. versus Schmeiser. Schmeiser. Interesting name. Um, they the court had defined the word use in that context, but it was a patent case. It didn't apply to using your cell phone. However, the Newfoundland Court of Appeal used it as sort of a guideline to establish, okay, what are the rules here for defining words? So what happened on the appeal was that the appeal judge used the definition from the Black's Dictionary of Law for the word use. Right, that's right here. So they actually literally opened a dictionary and looked up the word use, and the trial judge determined he was guilty. The superior court judge determined he was innocent, or well, not guilty. You're never found innocent. You're found not guilty. So was acquitted. Now the Court of Appeal is like, okay, we need some rules here, and so this is more of a interpretation question because the legislature here did not define the word use. They're leaving it up to the court to define it, which is common. Oftentimes, you will write laws in such a way that the courts are able to exercise their discretion when they determine how to apply that law. So that can be built in. And that, of course, allows you to adjust to an ever changing society. Now, there is a constitutional issue that was raised in this case. It was ultimately unsuccessful, but I'll mention it briefly. It was that the word use is so vague as to render the law unconstitutional. So the reason that we don't have vague laws, or the reason that a vague law would be unconstitutional, is it doesn't provide reasonable notice to people of what conduct is expected or disallowed under the law. You know, ignorance of the law is not an excuse, but if a person reads the law and cannot determine, okay, what can I do to not violate this law, or what can I not do to ensure I'm not violating this law, then that law is unconstitutional. It should be struck down. Now, again, that was ultimately unsuccessful because the word use has legal ramifications and it can be debated in the court of law. So there was enough there was enough substance in the law as it was written to allow the courts to come up with its interpretation. And so they found that when that option is available, then the law is not vague to the point of ambiguity. And so that that challenge was ultimately unsuccessful. So of course now we're looking at statutory interpretation. Now, of course, the court points out using the appeal judge's definition of use, which is sending and receiving a communication, and because the phone wasn't doing that at the time, not guilty. But that gives rise to some strange and surprising results. It would not include looking up a number in a telephone's memory, dialing, or reviewing numbers of people who had called, all of which are distracted driving. Like the intent of Parliament here, or the intent of the provincial legislature, was to stop people from using their phones, getting distracted, and causing crashes. And so that, of course, is another portion, another thing you have to consider when you interpret statutes. What was the behavior that Parliament was trying to dissuade with this law? So now, of course, we look at the context and the other words in the provision. Contextual given consideration to other words in the provision. So we are now looking at the rest of the law, which I'll scroll back up to here. What the other words in the law mean. And you were going to key in here which can receive and send two-way voice telecommunications without the aid of a wire or cord, except where that wire or cord uses power source and excludes two-way radio device. And a handheld cellular phone. Right. Of course, that just so that's just the handheld portion. So when you look at the other text around, we are looking at telecommunications, which is not just voice, right? We're also talking about text messages and other operations of the device. It's the device as a whole that we are concerned with. And so the court could interpret that the use of the device in its totality, so any use of the device, should meet the definition of use, which would include looking up a phone number in the phone's memory, surfing the internet, watching a YouTube video, talking on the phone, texting on the phone. All of those things would be included. So, here we are. And this is what the court concludes. The term use has a wider meaning than that given to it by the appeal judge, simply sending and receiving communication. As I just explained, it's the totality of the device and all of its uses. I would hold that use in the section of the Highway Traffic Act encompasses a variety of operations of a handheld cellular telephone that could result in the driver being distracted, including the actions as charged. Thus, I would set aside the decision of the summary appeal court judge to the extent that he has entered an acquittal. So therefore, the Court of Appeal is finding our unfortunate test case guilty. Or rather than finding him guilty, they're restoring the original guilty verdict. I should be clear in the language that I use. The Court of Appeal does not find people guilty. It is restoring the finding of guilt from the trial judge at the traffic court level. And then, of course, this is the discussion on the constitutional issue, which ultimately was set aside. It was not they did not buy this argument. So, appeal is granted. The appeal judge's decision is set aside and conviction entered by a trial judge is reinstated. There you go. One example of using a phone. All right. Let us quickly transition over. I should actually hide that. Let us quickly transition over to another case. And we have the Saskatchewan Court of King's Bench. Now, Saskatchewan actually defines the word use, meaning that they're not leaving it up to court interpretation. They're going to go ahead and provide the definition. Use means, with respect to electronic communications equipment, to use the electronic communications equipment to make a phone call, text, talk, email, or surf or access the internet, or for any other prescribed purpose. So a prescribed purpose would, of course, be an order in council that the minister could add to this list without having to pass a new law. It would still have to be relevant to the rest of this section. They couldn't stuff things that have nothing to do with cell phones into here. It has to be relevant to this, defining what the word use in the context of electronic communications equipment. So it gives them a little bit of discretion, but not a lot. And of course, once you have all the definitions, they put it together with the law. No driver shall use electronic communications equipment while driving a motor vehicle on the highway. On a highway. That also includes public roads. I mean, the highway, it does not mean, any street in your town. It They are considered highways in within this meaning of the law. So, of course, oh, I should actually go up to the facts of the case. So, a driver had held a cell phone up to their ear. Um, Same thing as Newfoundland, right? Same thing. The phone was up. But again, not using, not using the phone. There's no evidence. And in fact, again, once again, the Crown and the defense, the evidence was not in conflict. Right. So here we have Mr. Schaefer is the accused in this case. Um, I have no reason to disbelieve anything Mr. Schaefer's told me. I have no reason to disbelieve anything the Crown has told through their witnesses. So the facts are not in dispute in this case. Uh, the phone was not in use in terms of placing or receiving phone calls, text messages, surfing the internet, any of these uses that the court had laid out. So, and of course, making a phone call is defined in the legislation. We're not going to look at that because that, again, it was not. There was never evidence that the call was being made. That was not the fact in dispute. The fact in dispute, as we saw in the Newfoundland case, is simply holding the phone enough to meet the requirement of use. Now, the outcome in this case may surprise you. In Saskatchewan, it is not an offense to hold or handle a cell phone or a cellular phone while driving on a highway unless one is using it for the express purposes as defined. It is an error in law to find someone guilty of handling a cell phone when mere handling in and of itself is not an offense. So there you go. Two jurisdictions, two completely different outcomes because the wording of the law matters. In Saskatchewan, they have defined the term use and then incorporate that definition when they write the law. So they left the court very little room to use discretion here. So holding your cell phone in Newfoundland may get you a ticket when in the same circumstance, and of course back in 2011. So in response to this decision, the Saskatchewan government did amend their legislation to cover up that loophole. Again, irrelevant for discussing this because I just wanted to use these two cases to highlight that the exact precise wording of the law does matter. And what may be a crime. Now, again, these are Traffic Safety Act violations, right? So they're not true crimes; they're quasi crimes. They're provincial regulatory offenses. So you get a ticket; you don't go to jail. But it is interesting how two different sets of rules applying to very similar situations can come with two different outcomes. And you, as the driver, need to know what the rules are in every province you visit. Now, one of the reasons the court came to its conclusion, they state that, oh, here we go. Generally, it is assumed that legislators act rationally when drafting legislation, and that the interpretation should produce rational results. So when you look to a law, you don't want to read in things that Parliament didn't want read in. You don't want judges twisting words and giving them novel meanings where you start departing from the rational standard. Of course, it is the parliament, it's the legislature's job to make these rules. It's not the court's job to make law. It's the court's job to interpret laws. So legislature writes the law and then the courts interpret it. And what the legislature writes in and what they choose to not write in by omission matters a lot when it comes to interpreting that law. Now, of course, key here was that logical um, that logical interpretation, that rational results, rational laws produce rational results, led to the presumption that the legislator would not include a specific definition of a term if they did not expect that definition to be used in the interpretation. Logically, if use was to be interpreted as its general dictionary meaning, then the specific definition in the legislation would be pointless. Why would you write it in if you then intended to just go with the dictionary definition? So, in the end, our um, our subject here, Schaefer. Oh, that's a citation for you. Schaefer was the conviction was overturned and a new trial was ordered. Now, if the exact same facts were to have been held, it's possible that our friend, Mr. Schaefer, would have been found not guilty. But again, those are facts for the trial judge to determine. It was an error in law to read in a more broader meaning than was delineated in the law. So that was the reason for the appeal. Anyways, I hope you guys found that interesting. Leave me a comment if you have any questions. If you like this video, give it a thumbs up. It helps me get it helps get me visible. It puts my videos in front of an audience, and I hope that I can help people understand, how the law impacts their daily life. I hope this was informative, and I hope you enjoyed it. Now, for my next video, and I've got a great surprise for everyone. The next video is going to be covering Canada's Bill C-21 legislation. Now, of course, as I always say, I'm not a lawyer, and I'm even less of an expert in firearms law. So I reached out to an expert, and he agreed to collaborate on a video where we will be looking at a brief history of how kind of gun laws and our attitudes to guns have evolved in Canada. Of course, leading all the way up to Bill C-21 and its implications to law-abiding hunters, Indigenous people practicing their culture, and of course, like all laws do, what's its impact on criminals? Now, I'm not going to tell you who I'm collaborating with. You'll have to find out on my next video. So watch out for episode 7. Until next time, everyone, stay frosty.